Good evening, everyone. Thank you for being here tonight. My name is Dr. Rhiyan Quiton, Executive Director of Interim, Inc. Interim is a private nonprofit organization that provides mental health treatment, affordable housing, residential treatment, social support, homeless outreach, and supported education and employment services for adults who have serious mental illness. We own and operate 19 facilities, including 42 residential treatment beds and 264 housing beds. Our programs support more than 2,700 consumers each year. Interim's continuum of programs and services provide a bridge from institutionalization or homelessness to independent living. Special needs trusts are a critical legal instrument available to families and friends of individuals with disabilities who would like to use their assets for the benefit of their loved one without endangering their public benefits. We have an exciting discussion planned for all of us this evening, the goal of which is to support a greater understanding of special needs trusts and the common considerations that arise in establishing and administering a trust. I will add that this webinar is meant to provide an overview of special needs trusts for the general public. It is not a substitute for consulting with an attorney or professional fiduciary. Should you move forward in the process, we recommend you seek counsel with a qualified professional who has expertise in this area. In terms of the format, we're using Zoom webinar for this presentation, which means you can see us, but we can't see you. I'll be moderating a set of questions for our panelists. We'll be taking written questions during the panel discussion, and we'll have a dedicated Q&A period with our panelists following the discussion. If you have questions, please click on the Q&A button to post your questions in writing. We'll get to as many questions as time permits, and we have interim staff behind the scenes who will be responding to some questions in writing. Please do not put your questions in the chat area. If you do, you'll kindly be redirected to write your questions using the Q&A function instead. Please note, we are unable to provide any individual legal counsel during this webinar. This webinar is being recorded and all content and materials will be shared with you at the email address you provided during registration. Now tonight we have 3 individuals with us who have unique expertise in the area of developing and administering special needs trusts. I want to thank them for volunteering to speak this evening. Yvonne Ascher is a highly esteemed attorney at law, specializing in estate planning and trust law at Noland Hamerly Etienne Hoss in Monterey, California. Certified as a specialist in probate, estate planning, and trust law by the State Bar of California, she holds a master's degree in taxation. As an instructor at Monterey College of Law, she educates on wills and trusts and frequently addresses the public and professionals on estate-related topics. With numerous career distinctions, she chaired the California Trust and Estates Executive Committee and is a member of the American College of Estate and Trust Council. Thank you, Yvonne. Stephen W. Dale Esquire, LLM of Dale Law Firm, is a disability rights advocate specializing in special needs trusts. Serving on boards such as the ARC of California and the Contra Costa County Developmental Disabilities Council, he is deeply involved in disability rights activities. He oversees the Golden State Pool Trust and conducts continuing education programs for attorneys and trustees. A frequent speaker at national conferences, he's received awards for his contributions to disability law and is a member of the Special Needs Alliance. Thanks, Stephen. Fiona McDonough, a Georgetown University alum, has a diverse background spanning finance, real estate, communications, and corporate management. With graduate work focusing on post-traumatic stress disorder, she transitioned to estate planning and trust administration, eventually launching her own practice. Serving as president of the Monterey Bay chapter of the Professional Fiduciary Association of California, she advocates for individuals with disabilities and is actively involved in various legal associations. Thank you, Fiona. Thank you again to Yvonne, Stephen, and Fiona for being here with us tonight to share their insights and expertise. Now, as moderator for the next 60 minutes or so, I'll be asking our expert panelists a number of different questions, starting here with question 1. And this one's for Stephen. What is a special needs trust, and why should someone consider establishing one?
Okay, so we're going to try to cover this as best as we can because I probably could do 60 minutes on this alone, but we don't have time for that. And I want to thank you. Interim is such a wonderful and unique program here. So anyway, getting to that. A special needs trust, most people think of a special needs trust solely as a tool to preserve public benefits, and it's not that that isn't important here, but one of the basic things that a special needs trust does, and we're going to illustrate how that happens, I'm sure, throughout the talk, is that it's able to hold assets without interfering with essential government benefits like SSI, Medi-Cal, similar programs. Why would you consider one? Well, you could do it for a number of different reasons. For one thing, it could be used as a way to manage assets. Okay. And I think in a lot of ways, once again, beyond the public benefits, I like to think of them in many cases as a private social service system here. And irrespective of the benefits, for many folks with developmental disabilities, mental behavioral health challenges, and that kind of thing, once again, it can be kind of a private care management system here. It also can be very useful for tax planning. I'm doing more and more trusts here for folks who even elect not to have their loved one involved in public benefits, but it can be a great tax planning program. So, I mean, there's many things, and we'll probably illustrate that as we go through this.
Thank you so much, Stephen. Next one's for you as well. Now, who's eligible for a special needs trust, and how are they different from a regular trust?
Okay, so we're going to see two kinds of trusts here, and I think Yvonne's going to cover that in greater detail. If we're talking about the estate planning or the third-party trust, it can be anyone with a disability, and quite frankly, there's situations where I've set them up for folks that are not labeled with a disability. In a way, what a special needs trust is here, and maybe just melding this with the second question is what's different from a regular trust? A special needs trust is a form of a spendthrift trust, and that's one of the reasons that it keeps somebody eligible for beneficiaries. So as we all know, for folks on SSI, there's a $2,000 resource limit. And what the difference between this and the normal living trust here is that a special needs trust is a trust where the trustee has sole and absolute discretion and the beneficiary has virtually none. Okay. And because of that, you could put any amount of assets in the trust. I have a trust with a huge asset in it here, a lot of it for tax purposes here, and it can be held for the benefit of the beneficiary, but all distributions are in the sole discretion of the trustee. In a lot of ways, the most important person on this panel is actually Fiona. It's the trustee. Yvonne and I draft these trusts and all that, but part of this is giving this ominous power to this trustee. It's really important to have a trustee who is going to use that power of the sole and absolute discretion in the best interest of the beneficiary. Once again, just highlighting real quick the difference between like a living trust, which would be your normal trust, and a special needs trust. A living trust is what's called a grantor trust. It's basically, in most cases, when you transfer your assets in there, for instance, if you own a house, you should definitely do a special needs trust. Why would you do that? So that you can avoid probate here and pass things by a contract rather than here by a beneficiary designation or whatever. There's many reasons for that. If you contrast that with a special needs trust, it's a very different animal that once again, it's a form of a spendthrift trust where all the discretion is in the hands of the benefit of the trustee. And all the trust is used once again to benefit the beneficiary, but the beneficiary have virtually no control over the assets.
Okay, thank you so much, Stephen. So Yvonne, are there different types of special needs trust, and if so, which are the best ones?
So I'm going to take this question and the next question. So if you want to throw me the next question, I'm going to
Sure,
combine them
yeah.
together.
What are the differences between a first-party trust, a third-party trust, and a first-party pooled trust?
Okay, so what types of special needs trust? Well, we kind of get a hint of that from your next question. So I in my mind, everything is pictures. So I'm going to use a lot of picture analogies. So please forgive me. But I like to start and think about first party and second party as two flavors of ice cream. We've got chocolate ones and we've got vanilla ones. We're going to have some variations in there. We might have dark chocolate, milk chocolate, some vanilla bean, but basically there are two kinds of special needs trust: third party, first party. They're both irrevocable trusts, which distinguish them from your standard revocable trust. Again, back to our visual, I don't know if you can see, but I use this little bucket as an example for what a trust is. And during your lifetime, the lid is open. But when someone dies and you create a special needs trust, you put a lid on it. You probably can't see, but there's little holes in here where money can come out. And you can design these holes as big holes or little holes. So that's kind of our first or third party special needs trust. So what's the difference between the first party and the third party? The first party is funded with the person who's on disability's own assets. So they might have gotten in an accident and have a large settlement, but if they keep all that money, they're going to be off public benefits, and we want to preserve their benefits for a variety of reasons. This used to become really important when Medi-Cal was our only go-to for medical insurance. But since we now have Covered California and Medi-Cal rules have become a lot easier to access, preserving, creating a special needs trust, a first party special needs trust with your own money so you can access those benefits isn't as important, but it's still important for SSI. But if I have my own money and I'm disabled and I want to keep my benefits, I have to somehow get rid of my assets. And one way to do that is to create this government approved by the Social Security Administration first party trust where I'm going to give my assets away and I'm going to be able to retain my benefits. And there's ways of doing that, and we won't go into the details of that. A third party special needs trust is where somebody else is going to fund the trust for you. It's going to be their assets. And that's what we generally see. Mom, dad, grandma, brother, sister say, I want to take care of you, but I don't want to just hand you this money. One, maybe because you can't manage it, but also because I want you to be able to still get benefits. So I'm going to give it to you in the form of this special needs trust, a trust with a lid on it. And that's going to allow you to retain your public benefits because of the terms of the trust. It meets certain requirements that as Stephen talked about, the person doesn't have access to say, I just want that money. There are restrictions on their ability to get it. They don't have discretion to give it, and therefore the government doesn't count it as available to them, and it's not going to affect their benefits. Within the first and second, there are, like I mentioned, there are variations of the flavor. And the way I primarily look at that is some of them are very strict. Holes are very defined, no wiggle room. I can only give you money from your special needs trust for things that the government doesn't pay for. So because SSI is supposed to pay for housing, I can't help you with your rent. Tough luck. No bananas. But most special needs trusts are a little more discretionary and said, you shouldn't give someone money if it's going to affect their benefits, but I'll look at the overall amount of money in the trust, and it may be that I should help you with your rent, even though you're going to lose some of your benefits. That's more of our dark chocolate variation of our special needs trust, where there is some discretion in the trustee, not in the beneficiary, to administer it a little more broadly to look at quality of life issues. Now, within both of those kinds of flavors, you can have what's called a third party, a pooled income trust, a pooled trust. You can have a first party pooled trust or a third party. And we're so fortunate to have Stephen here because he has a lot of experience with pooled trusts. But pooled trusts are trusts that are administered by a nonprofit, and they pull a whole bunch of people's special needs trusts together and administer them kind of as a master pooled trust, and everyone has their own account, but there's one standard trust agreement, either first party or third party. And the pooled trusts are wonderful options to look at where you don't have a good trustee, or maybe there's not a lot of money to justify having your own trust. For example, in my trust, I say if the trust falls below 100,000, the trustee has discretion to give it to a pooled trust. I just did one where we're giving it to a pooled trust in Los Angeles because the beneficiaries are very young, and we don't know of anyone who will want to be around for the next 75 years to administer it, and we're pretty sure the charity will be around. Every pool trust is a little different. And again, Stephen, correct me if I'm wrong. A lot of them provide that when the beneficiary dies, a portion of the money goes to the charity. That's how they justify their fees.
Some do.
Yeah, some don't. Some that can say maybe a percentage goes. Some of them have an annual fee for managing them. So they're different pool trusts in the state that you would want to look at if that's an option you want to be looking at.
Thank you so much, Yvonne. And forgive me, you may have alluded to this a little bit in just your last response, but what is a revocable trust, or when is it needed?
Okay, so revocable trust, I think we have this question later on, but a revocable trust is a trust with the lid open. So the person who created the trust can reach in here, take my instructions and change them and do things differently. The reason many people do a trust in California is to avoid the probate process. Because I take my house, I take my financial accounts, and I put them in the bucket, and I technically don't own them anymore. They're owned by the Yvonne Ascher bucket. So when I die, my heirs or beneficiaries don't have to go to court to move the assets from me to where they're supposed to go because I don't own them. They're in the bucket, and the bucket didn't die. And the set of instructions in here says, my son, my husband, my professional fiduciary can reach in here, look under the lid, and administer the assets according to the instrument. So,
Okay.
you know, a lot of people think that it has creditor protection, it has tax benefits, and really, while you're living and the lid is open, it's just like I own it, but legally I don't hold title, so we don't have the probate process.
Thank you, Yvonne. And I know it'll be different for different situations, but who should write the trust?
Oh, that's a question to me. Okay. So trusts are really fairly complicated and sophisticated instruments. And so I, of course, I'm a little biased. I believe, you know, everyone should see an attorney to write a trust. I've seen lots of trusts that people do on their own, going online, going to Zoom, but and maybe with AI, it's going to be a little better. I don't know. I haven't done an AI trust yet. But you know, the trust is only as good as you know, the person writing it understands the nuances. So if you are trying to do it on your own and the computer program says, do you want A or B? You can have both. And you're not sure what A and B mean in the first place. You're going to say, sure, give me both. And so sometimes maybe you have competing clauses, or you're not very clear, or you haven't. Someone, one of the benefits I think about having an attorney who's experienced in this area is they can play devil's advocate. So like you may think, oh, my son loves his brother, he's going to be the best trustee. And then you go to see an attorney and they start saying, okay, here's what Thanksgiving is going to look like if you do that. You know, your one child's going to say this and the other child's going to say, well, I'm not giving you any money, you know, and it maybe isn't good for their relationship. So having someone who's done these and has seen what I call the backside, which no one here has seen the backside because we're not dead. But I've seen the backside lots of times, other people's backsides, not mine. I can bring that experience to the table and share, you know, maybe how to design the trust from a practical point of view so it's going to accomplish your goals better.
Thank you so much. So, Stephen, which type of special needs trust is the most restrictive and why?
Well, let me jump into that. I do want to piggyback on
Sure.
what Yvonne said real quick, which is, and by the way, I agree with everything that Yvonne said. You know, when you're looking for an attorney, I think too many people look at these things as commodities. and they're not. It's what I call the magic document syndrome. So part of this, when you're choosing an attorney, I think it's important to choose somebody because you're buying the experience of the law firm. You shouldn't think of it as a document. So just piggybacking on what Yvonne said, the other thing is, I think when you're looking for an attorney, somebody who's had experience in helping on the administration of the trust, because I'll tell you, you learn a lot in the actual administration. When I first did this, I had no idea what I was doing. And believe me, I learned as I went. Getting back to the question and back on the program, what is the most restrictive trust? As Yvonne said, you can categorize special needs trust into two types of trusts. One is the first party trust. The other one is the third party trust. The first party trust are the assets of the disabled individual, usually from a probate where it didn't go directly into the trust, or from a personal injury settlement or that kind of thing. In that trust, you're basically making a bargain with the government. And part of the bargain is that this is an irrevocable trust. And when the beneficiary passes, there's a lien for any Medi-Cal you've used during your lifetime. So this has a lot of restrictions, like you can't use it for gifts because they don't want you giving it away and avoiding the payback here. And there's a lot more scrutiny. Now, a third-party trust, which is when it comes from a family member, and it could be from a parent. I set up one for my niece who has Down syndrome, so it could be from an uncle. It could be from anybody, set up by anybody but the disabled individual themselves. In that case, there are a lot fewer restrictions. You have a lot more latitude here. And especially when you're dealing with folks with behavioral health, you can set it up where it turns on and it turns off and it adjusts. Once again, part of this is, think of it as putting together a little social service plan here. Part of this is, like, if Fiona is going to be the trustee, we need to give her guidance on what is it we want her to do and that kind of thing up here. But it has a lot of latitude, including saying on occasion please go ahead and make distributions, even if it causes a loss of benefits. It just really has a lot of latitude.
Okay.
So
now you've this next question here, I think you spoke about it, Stephen, very well, but if there's anything you could add or expand to it, are there maybe standard limitations for the use of funds?
in some ways, yes, in some ways, no. And I think one of the things that comes up, boy, if I could eliminate the word special needs, I would do it in a heartbeat. And by the way, it's kind of fallen out of favor anyway. There is no such thing as a special need. Whatever need the beneficiary has, that's their special need. Now, within that, we have to be careful what we use it for here. So for instance, one of the biggies is food and shelter. If the beneficiary is on SSI and you use the funds for shelter, you'll have a loss of benefits of $334.33. I could explain to you why, but I can't give you a rational explanation. It's just a bunch of stupid rules here and that kind of thing. So sometimes you have restrictions that will have repercussions, but once again, it would be pretty stupid to have a trust that says I can't house my beneficiary, because what is it that people need? They need housing, that kind of thing. You generally, for folks that are on SSI, cannot give them cash. So you have to pay for things indirectly. I know when I'm working, as a fiduciary, as a trustee with the Golden State Pool Trust, the first thing the beneficiary asks me is, how much cash am I going to get? And the answer is 0. And they're excited about that. But I'm sure Fiona will go into, well, then what good is this thing and how do we get things to them? So once again, in a third party trust, you can have a lot of latitude. In the first party trust, it's a little bit more restricted. But in the end, it's the skill of the trustee that matters.
Okay, thank you. And this is also for you, Stephen. What are discretionary distributions?
Well, I've been doing this for a long time here. I've actually identified 7 people that say they invented the special needs trust. It wasn't me here. Although, as I like to say, when they're all dead, then I can say I claimed it, but I didn't do it here. When they put this thing together, because they didn't know what they were doing, but they, kind of figured out because of the asset and resource limitations for these programs. If you took a spendthrift trust and kind of monkeyed around with it, it would work. The earlier trusts were what I would call the more restrictive trusts. And oftentimes what they said is you can't make a single distribution if it's going to cause a loss of public benefits. What did you just do? You created a trust that, for instance, if they're on SSI, you couldn't use it for shelter because if you pay for the shelter, you're going to have a reduction in benefits. Just using some common sense. In a lot of cases, if we don't have other alternatives, of course, we want to pay for that shelter and take that reduction in benefits because housing is a big issue for all Californians, especially people with behavioral health limitations. So once again, a supplemental trust tends to be a very restrictive trust here that really strictly says that you cannot interfere with making a distribution that will cause a loss in benefits. I don't remember the last time I did a supplemental trust. A discretionary trust gives the trustee the discretion to use a little common sense. And there are times when preservation of benefits is not really in the beneficiary's best interest here, and we want to give the trustee that latitude.
Thank you, Stephen. This next question, and Yvonne, you alluded to this a little bit with SSI or Social Security income. How does a special needs trust ensure that an individual's SSI is preserved when drafting a trust?
Great, but I want to go back because Stephen pointed out something that I didn't say when I should have been talking about the difference between first and third party special needs trust. And I just want to highlight it. When you create a first party special needs trust, it's your own money. And as Stephen said, when you die, the trust must provide for a payback provision. We'll talk a little bit more, but I wanted to highlight that to make sure that's on everyone's radar because I missed it. Thank you, Stephen. And the other thing I just want to point out is one of the first things that a lot of times people, when they come to me to draft these trusts, they don't know is what kind of benefits is the person on? Because if you're on SSDI, Social Security Disability, you don't have a lot of these restrictions. And so most of what we're talking about when we talk about these restrictions is for those that are on SSI. Now I'm going to get to your question. Okay, so SSI rules say that if someone has one of these trusts that limits that one is not generally not their own money, and that limits their ability to get the assets, that SSI will respect that and not considered available to them. So because there's a lid on it, and the beneficiary can't say, just give me the money, it's not counted as a resource for their benefit. And then the issue, as Stephen alluded to, is, however, if sometimes a distribution is used for the things that Social SSI is supposed to be used for, housing and shelter and food, that will cause a loss of benefits.
Okay. Now, is there a payback, Yvonne, due back to SSI for inherited assets?
Okay, so let's just say, is there payback due to SSI from a special needs trust? Because the assets that are in there may be inherited, or they may have been gifted. We don't quite know how they got in there, but the answer, the short answer is no. SSI does not have a payback provision in any either first party or third party. Only thing that gets paid back is if you have a first party special needs trust, Medi-Cal can get paid back. It is required to be paid back. It's going to be interesting because recently, just this year, as many of you maybe know, Medi-Cal changed their eligibility rules and no longer look at how much assets you have. And they also a couple of years ago changed their reimbursement rules. So when you die and you got Medi-Cal, you don't have to pay Medi-Cal back unless you have a probate estate. So first party special needs trusts are also the only other source for Medi-Cal reimbursement is under California law right now.
Okay, thank you. Stephen, who can put money into a special needs trust?
Okay, and we're just going back to this, there's kind of a schism here. In a first party trust, it's meant to hold assets of the disabled individual. And in a way, looking at the differences will show you that you want to avoid the first party trust if you can. So for instance, if you don't do proper planning and you don't direct, your assets for your loved one here with a disability into the third party trust. Let's say you have a life insurance policy and you didn't change the beneficiary designations here, then that will go to the disabled individual themselves. And at that point, the disabled person can put it in the first party trust. That first party trust is going to be a little bit more restrictive. Remember the payback here, and there's going to be a lien upon death for any Medi-Cal they've used during their lifetime. And that's in any state. So one of our greatest exports in California is Californians. Merely moving out of California isn't going to resolve the issue. You're going to have that. In a third party trust, a good illustration is that I set up a trust for my niece in New York. Here, all the aunts and uncles are contributing to that trust. So usually it's the parents, but sometimes it is, aunts and uncles. It could be anybody except the person with the disability or their spouse for the kind of trust that we're talking about here.
Okay.
And just once again, just going back to illustrate it, for families that are watching this, one of the biggest mistakes out there is to set up the trust and not properly fund it, meaning making sure that everything is designated to the trust directly. And if you don't do that, then all you have is a nice piece of paper, and you're going to end up with a first party trust, and all the work you did is going to be for naught. So it's really important to get this right. And it's more than just drafting a document.
Okay.
Yeah.
Thank you. And Stephen, do you need to assign a successor trustee?
You should. Well, you need one. The most of these trusts are trusts that don't actually go into management, go into administration until until the grantor, the person that set it up, passed away. That's not always true. There's times when you do it before that here, but that's what you normally do. And so, well, you need to name a successor. I have to tell you, and let me illustrate something. I know this might be kind of silly, but I use her all the time. We're going to call her Kathy. Let's say Kathy has autism. Okay, to my knowledge, nobody's ever died of autism. Let's say she's 17 years old. The parents go down to Yvonne's office. They get this wonderful trust put together. And I know Yvonne's going to properly fund that trust and all that. And let's say they go to San Francisco. The parents always say, if I get hit by a bus, if you go to San Francisco with Muni, I've had 3 deaths. All kidding. Don't step in front of a Muni bus here. She's supposed to live for another 70 years. Okay. Now I can see that Fiona is a little younger than the two of us, I'm guessing. Here, I don't know that for sure, and we're not here to do that, but will Fiona be here for the next 70 years? And I'd go, well, that would be amazing. So, part of it is not just look at naming the successor trustee, but you also have to remember that these trusts last a long time here. So once again, a skilled practitioner is going to not only draft this thing to make sure that we have the trustee that we want at the time, but there's some method of succession that makes sense here and also keeps as many options open as possible. Because I have had people wanting to name their 6 and 7-year-old nieces and nephews as trustees. And I'm just going, that's just not absurd. I'm not doing it. Part of it is not only naming something, but having some process where we can keep that succession of trustees going. If we run out of succession of trustees and it's not drafted by a skilled practitioner, we're off to probate court to name somebody. And let me just give you a clue. Anytime we're off to probate court on these things, something went off the rails.
Thank you, Stephen. So Yvonne, I don't know if this is a fair question or not, but what is the average cost to draft a special needs trust?
So generally, as we've kind of talked about, generally a special needs trust is included in someone's living trust. So you create a trust to avoid the probate process, and then your trust says, when I die, my assets go partly to my son Jimmy and partly to a special needs trust for my sister Susie. So it's usually in conjunction with creating your entire estate plan. So generally, we don't just create a standalone special needs trust as part of someone's estate plan. So it's hard to give general cost, but a special needs trust shouldn't add, let me maybe say it this way, is if you talk to a person about doing an estate plan for you, which includes a trust as your primary vehicle, and they give you a range, your special needs trust is going to bump it up towards the higher end of the range, maybe about a couple $100, because it does take a little bit more drafting and a little more consideration. But especially the language is generally pretty standard unless you have a very unique situation. So it's not like it's a lot more money than I'm setting up a trust for a minor. Maybe a little bit more complicated, maybe a little more discussion about how wide you want to make those discretionary holds or not, how much we think there's going to be funded, how important public benefits are. But the document itself is not overly complicated. As Stephen's talked about, the complexity is actually administering the trust, and Fiona's going to talk about that. So it doesn't add a lot to the cost of creating an estate plan.
Okay, so a couple more here, Yvonne, and I'm going to do a twofer on this one. What's the difference between a special needs trust and an ABLE account, and how can an ABLE account be used in conjunction with the special needs trust?
Great question, and we could do also a whole program on ABLE accounts. ABLE accounts are a new tool that we have in our toolbox that came in a couple of years ago that was authorized by the federal government. Then every state had a right to set up their own ABLE accounts. California has one, and they're kind of like a cross between an IRA and a special needs. But what it is the money in the ABLE account. You can create it. You can only there's limitations on how much it can be, in the state of California manages it. But the beneficiary can actually take money out of the ABLE account themselves and use it themselves for certain qualified expenses. And in some cases, that may even be food or housing, as long as they use it in the month of receipt. So it was designed for people that have capacity and need a little bit of spending money, but we had the $2,000 limitation. So you could have $50,000 in your ABLE account when you could only have $2,000 in your bank account, and that $50,000 is, if I'm the disabled person, my money that I get to use, even if it came from someone else. So in conjunction with a special needs trust, what I've been doing for the last couple of years since we've had this tool in the toolbox is I've authorized in my third-party trust for my trustee to be able to open an ABLE account for the beneficiary so that they can have that discretionary money. So the tools can work together. They're not necessarily exclusive. Like I said, we could have a whole program on who can put them in, how much they can use, what they can use for qualified expenses. But generally, you only create an ABLE account where you trust the beneficiary not to misuse those funds. So if they're totally disabled and don't have the ability, yes, they can nominate someone else to use it for them, but then you don't really need it because you got your trustee. So it's a way of giving them some independence and some self-governance without affecting their benefits.
Wonderful. Thank you. Thank you so much, Yvonne. So I know Fiona's probably been sitting on her hands for the last half hour. This question's for you, Fiona. Who should administer a trust, and should it be a family member?
I think that family members are great advocates and liaisons with a trustee, but I think that a professional fiduciary or an attorney should be the trustee, because there's a lot of, as you have already heard, a lot of rules and regulations concerning the administration of a special needs trust.
Okay, thank you. And Fiona, what areas are common for a fiduciary to be proficient in where special needs trusts are concerned?
So public benefits, finances, and just knowing what resources are out there, and having a good network of people that help get you in touch with resources, especially cost-effective resources.
Okay. Should you have a backup fiduciary?
Yes,
Okay.
yeah, to do that. Mhm.
And what's important when choosing a fiduciary or a trustee?
So you want to have someone who is, demonstrating that they are obeying a code of ethics for fiduciaries. Someone who is neutral, who's not in a position of conflict in the context of the trust, and then someone whose fee schedule is something that is going to be feasible for the trust to cover, and that is comfortable for the grantors. Different fiduciaries charge different fees.
And if I could ask, what are some of the more significant trustee duties?
So making informed decisions, investing the assets prudently, retaining an attorney who is an expert in the area of special needs trusts, doing the taxes, doing the usually there's a yearly accounting that has to be done, which basically goes over the expenses and distributions, and is then given to the beneficiary and the grantor. Um, uh, there's hiring caregivers if necessary. So there's sort of just like some management that goes into
Hmm.
administering the estate and providing a quality of life. There's bill paying. So yeah, those are some of the things that.
Yeah. Are there other professionals not mentioned that are needed to maintain a trust?
Financial advisor, CPA. I've already mentioned care manager and attorney.
Okay, thank you. And what are trustees' fees? How are they determined? I don't know if that's a fair question or not, but
Well,
speak to
trustees
that.
determine their own fees, but there's sort of a market rate in various regions of the state. Uh, Often those are sort of around the fee schedule set by the probate court for probate administrations, um, but not necessarily. It depends on the fiduciary and their experience in the
Okay.
area that they're in.
Okay. Now the next question I like to ask has to do with liability. So is there a difference between, in terms of liability, with a professional fiduciary versus a family member per se?
Yeah, so a professional is held to a much higher standard legally than a family member. So a court will scrutinize much more carefully what a professional fiduciary does, and
Okay, so
be way and yeah, there will be more leniency for family members.
with that, would you mind speaking to us about like legal protections? I'm not sure exactly what to call it, but legal protections, if what kind exist for the fiduciaries or oversight of the fiduciary?
Yeah, so there's the Professional Fiduciaries Act, which created the Professional Fiduciaries Bureau, which I think it was 2006. So it basically oversees licensing, enforcement of rules and laws. So it's most of it is within the professional code, and then there's some points in the probate code.
Okay.
So, for example, you can make a complaint about somebody to the Professional Fiduciaries Bureau. They have to investigate it. They can remove someone's license, at which point they're not legally allowed to practice. You can also bring a breach of fiduciary duty lawsuit against a fiduciary.
Okay. Okay. Thank you. And um,
Can I jump in with what?
yeah,
Okay.
absolutely.
So
Absolutely.
Fiona reminded me that having a professional fiduciary is generally strongly recommended versus a family member because of the dynamics if the person has some mental illness. If they're maybe just physically disabled and it's pretty straightforward as to what their needs are, that's kind of a very different beneficiary you're going to be dealing with than someone maybe who is mentally unstable or has some baggage with their, maybe a sibling or a family member, which would create conflict. So having a professional is wonderful. But in a lot of cases, someone wants someone overlooking the professional fiduciary to advocate for the beneficiary, to see the accountings because they're not able to understand it. And so you can name someone called a trust protector. And a lot of times a trust protector is a family member who can get copies of the accounting, who can look at what the professional fiduciary is doing in terms of an investment and serves as a checks and balance. And a lot of times that will be a family member. And then they can appoint a successor. So there's always maybe a family member there to advocate, but they don't have the legal responsibility of doing the job. They're not getting the phone call saying, I want more money. They're just kind of in the background, but it's a nice checks and balances. And so that's another tool in the toolbox that we look at for special needs trust a lot.
Thank you so much. I appreciate it. So maybe one or two questions for this segment before we segue into the next portion of the webinar. Fiona, what are some common issues or considerations that a fiduciary might have to address in administering a special needs trust?
Yeah, so, you want to make sure that you know what benefits someone's on, and you know what exactly is in the trust, because different special needs trusts have different language and requirements. Another thing is that, it's not a magic pill. Like as Yvonne was saying, it's basically, it's a container. And Stephen was saying this as well, but if you don't administer it properly, if you don't have things, titled properly, or if you give somebody money directly when they're on SSI, just because you have a special needs trust doesn't mean that it's a magic bullet and you're not going to face repercussions for that. So the other thing is that a special needs trustee cannot basically there's the individual beneficiary's rights are still protected. And for example, if they don't want to cooperate with applying for public benefits, sometimes people think that the trustee can make that happen. That's not really true. I mean, the trustee can try to establish a relationship with a beneficiary, encourage them to do it, and often I'm successful at achieving that. But if somebody absolutely won't do it, it's their name and they have to, if they have capacity, they have to be the ones applying for these public benefits. And there's only so much a trustee can do, so that's sometimes when we get into conservatorship territory. And another thing is if someone is demonstrating have difficulty in doing those things that they need to do, handling the Medi-Cal applications and things like that, it's often you can avoid a problem by getting them to appoint you or someone else as a power of attorney, and then you can become their rep payee with Social Security or Medi-Cal, and you can handle a lot of those things before it gets out of control. So it's about being able to create that trust and that relationship with a beneficiary where they'll let you do that. I just came onto a case where it's been almost 3 years where he's just refused to let anybody help him. He's, insisted that he can do it on his own, and he's almost lost his Medi-Cal. And luckily I've been able to establish that relationship where he's signed over, power of attorney and rep payee to me, and we're gonna save his Medi-Cal. And so it's about establishing the trust and the relationship. The other thing is that, when you're considering whether to do a special needs trust or not, if somebody's not on SSI, or even if they are, and there's a substantial amount of money in the trust, it's something to consider whether you want a regular trust or a special needs trust, because as we're talking about, there's, a special needs trust is, in the reason for it is to preserve public benefits. So there's even if there's a lot of discretion, that the trustee can determine, how to distribute and preserving their quality of life and not keeping them at a welfare level if it's not necessary and if it's detrimental to them. There's still a certain amount of language in there where you're supposed to be, more conservative, and then you have to look at who are the remainder beneficiaries, who are supposed to inherit this money if the first beneficiary of this special needs trust passes away. You have a certain obligation to them that you have to consider that too, with if this is a trust where it's supposed to be preserving public benefits and you're supposed to be preserving the trust assets, and then you have this obligation to remainder beneficiaries. There's those things to balance as well. So that's just another thing that can come up with special needs trusts.
Thank you, Fiona.
If I could respond to that just
No, absolutely.
real quick. Oh, although I'm butting in, but you can stop me. Just one thing with it, and just to kind of illustrate putting this all together. Part of this with all trusts is it's the intent of the grantor that matters in the end. In the end, that's what matters. There's a couple of ways to do that. For those of you that don't know me, I was actually a psych tech for 17 years before I became an attorney. So I have more involvement with the behavioral health community than sometimes I wish that I do. And a lot of times when you're dealing with folks with those kind of issues, there's some very specialized drafting you might want to look at. I am getting more and more folks that are saying that I do not want that mostly we're using this to manage funds and quality of life. And so you can, both by including this in the trust, and there's another animal called the letter of intent, kind of a side letter. Basically, it would be a letter to Fiona if she's the trustee about this is what I want for my child. So I'm getting more and more folks that are saying, I just want to make sure this money's managed right. If there's something with public benefits that's good for my child, that's fine. But I don't want them in public housing, whatever. I'm happy to pay fair market rent. And one of the things also you might want to put in there is I get more and more clients who say, I don't really care about the remainder beneficiary. If you spend the last $2 the day before my child passes away, that's fine. But this is where the drafting comes in, and a skilled drafter that has experience with these kind of things is really getting into the head of the grantor, the families that are setting it up. What is it you want? Think about these things and all of that. The other thing about this, oftentimes there's a resistance to using a professional trustee because, of course, they charge. Here, I'm assuming Fiona's not a nonprofit here, but that I work for a nonprofit and we charge too. But the thing about it is, I'll give you an illustration. I had a trust I did a number of years ago on somebody's deathbed. I urged them to hire a professional trustee. They did. They say, I have a son. He's a lawyer. He's really smart. Let me tell you about the call we had today because we're going over it. He had bought for his brother a van and a motorcycle, and the person's on SSI. He says, well, that's okay, right? I'm going, oh, we have a problem. You can only have one vehicle. And he says, well, that doesn't make sense. I go, no, it doesn't. But those are the rules. And here's the problem, that if this person is reviewed, they're going to get knocked off of their benefits and that kind of thing. So once again, I'm a big fan of using professional trustees. I'm a big fan of using professional trustees with guidance from family here as a team. But once again, like the motorcycle and the van, why shouldn't a person on SSI have a motorcycle on a van? I can't give you a good reason, but the reason is it says in Social Security world, you cannot do that for persons on SSI.
Thank you for that example, Stephen. Now, before we get to the next section, is there anything else, and I'm throwing this to the panelists here, anything you'd like to touch on or cover? Maybe someone said something that sparked another important either topic or information you want to share.
I just want to emphasize again, I think what we're hearing as a theme is that we still use the term special needs trust, but more and more we're now drafting these as discretionary trust for someone who can't manage the money themselves. And so really, it used to be in the old days, and I'm old enough to remember, when getting Medi-Cal was really a lot of the reason why we did these trusts, because especially for people with mental illness, their meds were so expensive that we needed Medi-Cal, and that was the only way they could get insurance. We've kind of evolved a little bit. Hopefully we're continuing. We're now public healthcare is more available, so we're less concerned about preserving benefits. But that benefit was a lot of times much more important than the SSI benefit. But now, because we can access Medi-Cal through a couple of different ways, these trusts we should start talking about them as discretionary support trusts and not really special needs trusts.
Thank
I
you,
think that's a
Yvonne.
good point. I have a lot of trust, especially when we're dealing with folks with behavioral health issues, where they don't want to be labeled as special needs. So sometimes just changing the name to a discretionary trust is just a little bit more palatable. It's the same trust.
Thank you. All right, anything else from our panelists at this time? Because more questions are coming.
Oh, there's so much we could cover, but
Right,
we
right,
need to
right.
get to the most terrifying part of that, which is the questions from the families.
All right, well, I want to thank our speakers for this informative discussion. At this time, we'll segue into our Q&A portion of this webinar. As I previously mentioned, please utilize the Q&A function. Click on the Q&A icon and you'll open a submit a question prompt. You can submit one anonymously or with your name. I'll be asking our panelists to answer several questions now, but for any unanswered questions, we'll send out follow-up answers to you after the webinar, as well as a link to the video recording and any resources that we dropped in the chat. Again, please note that we're unable to provide any individual legal counsel during this webinar. Okay, first question here. Let's see. So our special needs trust, and this is to whoever would like to field this question, are special needs trusts only for disabled beneficiaries?
I think we've touched on that quite a bit, is that no, let's maybe start here calling them discretionary irrevocable trust, because that's what they are. Is they're an irrevocable trust that is just where a discretion is given to the trustee for somebody who needs assistance in managing their financial affairs. This is so it's not just for people who are disabled. They can have just because you don't trust them. So,
Okay.
Well, by the way, another common use for a third-party special needs trust is for seniors. Although I don't sure I like that term because I'm 72, which makes me a senior. I don't feel like a senior, but I guess I are here. But, once again, I have a lot of clients that are concerned about their aging parents and that kind of thing that, may be on Medi-Cal or might need Medi-Cal in the future or have those funds or need those funds. So basically, in a case, I get more and more folks who do this for seniors. I do a lot of these things because of my mental health background. For folks with behavioral health issues who may not in the future qualify for benefits, but they have their challenges. Once again, you need to keep in mind what this thing is a glorified spendthrift trust here, and so it'll also protect money from creditors. One of the problems we have when we have somebody with, for instance, a mood disorder, oftentimes you'll have folks who will do remarkably well for a period of time, and then they won't, and then they will. That's just part of the cycle. And so many families will set this up here to protect them from the problem times and that kind of thing. I mean, it really does have a lot of different uses. Benefits are actually it used to be the only reason for doing this. More and more benefits, I'm getting more and more trusts where benefits are not even in the mix.
Thank you.
I mean, one of the questions, who on this panel would like to be on SSI themselves? Not me, right? I mean, so, in a lot of cases, it becomes a necessary evil and something we need to do. In fact, another thing that I'm using special needs trust more and more is encouraging folks to work and using it for vocational training and hopefully get them off the benefits someday, which in many cases, that is the road to true independence, if that's a path you can take. Once again, our goal is to work on having the best quality of life possible within the resources we have, both public and private. And that should be our goal.
Thank you. So is a beneficiary who owns property not qualified?
No,
Yeah, I mean, if the beneficiary has their own house, but I'm their parent and I don't want to just give them the money, I can create an irrevocable trust when I die that someone else is going to manage, of which they're a beneficiary, and it doesn't affect what they own. The question I think is maybe getting at, does owning the house affect their benefits? And generally no, because it's an exempt asset.
Okay,
So
thank
sometimes,
you.
also in the trust, we sometimes buy a house if they don't have one.
I did a webinar this week on buying a house. I mean, it was pretty involved in it and that kind of thing. In a lot of cases, my preference is that the house be held in a third-party trust. But there's a couple of things with this, and I have to tell you that housing obviously is one of the biggest issues that we deal with here. And there's some practical concerns here, because one of them is oftentimes people will put house in a trust, but they won't leave enough money for the maintenance. Well, guess what's going to happen eventually? Secondly, one of the things between the beneficiary owning it outright and owning it in the trust is somebody's got to manage it. And there's a lot of fiduciaries that are not wild about managing the house and all the responsibility that goes with that. So part of it, you have to look at whether it's practical. One of my concerns oftentimes because on all of these benefits, the government favors persons with disabilities owning a residence. So you can do that. But the problem with that is we get back to somebody who might have a behavioral mood disorder, you're really putting things at risk, here in a case like that, where, there's a danger of the loss of the house and that kind of thing. And the other problem with it is if the house has to be sold, you may have a problem staying qualified for benefits, depending on what kind of benefits you're on. I have to tell you that these are not easy issues. They're complicated. They're more convoluted than you think they ought to be. Here, I don't think the word disability and simple are two words that go together. They just don't.
Thank you. Thank you for fielding those questions. So I'm hoping I get this next one correct. So we did talk a lot about pool trust already. But do you recommend any specific ones, whether pool trust or trust, for small estates, or when there's a lack of a successor trustee?
Be that I manage a pool trust and have 250 beneficiaries. How about if I jump on that first? I will disagree with one thing that was said here is a lot of people look at pool trusts as only for small funds. I totally disagree with that. Okay. Here, once again, if a pool trust can handle a small account, it can handle a small account. But even so, here, the most pool trusts are call centers. Okay. Golden State Pool Trust is like most pool trusts. We do not have our own care managers and that sort of thing. So I am never going to see the beneficiary. It's not going to happen. I either have to take my direction from the beneficiary, from a family member, which we call a BA, or that kind of thing. That's the way that most of the pool trusts work in California. If I'm looking at something where we definitely need hands-on, I'm going to lean more towards the private professional fiduciary because they actually go out and see their own people. Like if I had somebody in Monterey and I can't communicate with my beneficiary because they're unable to do that, I'm going to be either hiring a care manager or a private fiduciary. And now we got two levels of administration going on. That just doesn't make any sense. The way I like to draft these things here is to leave all option open. In fact, what I'd like to put in the trust is, like, let's say we're going to name Fiona here, I would name, Fiona and her fiduciary group, or a private professional fiduciary, corporate trustee, or pool trust of the trust protector or advisory committee's choosing. That opens it up for all the different possibilities, because what's right for the beneficiary at that time. But the thing is, and this is where, once again, a skilled attorney who understands these things can help you with the guidance. There is no one answer that works for everybody, and that's just not how it works. A lot of it has to do with how much money we're talking about, the complexity of the issue, and that kind of thing. Is there a particular pooled trust? I actually, even as the trustee of a pooled trust, I recommend a number of folks. Somebody mentioned probably the JLA Trust in Los Angeles, a very fine trust. By the way, I wrote their trust document, a very fine trust. And they actually have care managers, if you're in Los Angeles, that will go out and actually see somebody. Each of the pooled trusts has their strengths. Each of them has their weaknesses. Each of the options have their strengths, and each of them have their challenges.
And as Stephen alluded to, when the beneficiary dies, some pool they're run by nonprofits. So some of the money sometimes goes to that nonprofit to support their other missions. So if you're affiliate, if there's one that has a mission that you are that you want to support, that may sway you one way or the other.
Thank you. Appreciate it. Next question here is, what about other children's when you do a special needs trust? So I imagine if you set someone up for a special needs trust and there are siblings, I imagine, what about them? How does this impact them?
It doesn't. I mean, it doesn't affect them any more than any other kind of estate planning. So you can provide for your other children. One of the things that a lot of times, and this is why you want to have someone who's experienced in this, is you want to look at the nature of the assets that you have access to and where are they going to go. So for example, a lot of my clients have a very typical asset portfolio of retirement accounts, maybe a house and some money in the bank. Well, they've named all three of their kids on their retirement accounts, and one of them is disabled or needs some assistance. Well, that's not going to work, because that person then will get the money from the retirement accounts. So a lot of times we talk about, okay, just name your two children that can receive the funds outright as the beneficiary of the retirement account, but design a formula in your trust that says, look at my assets globally and create 3 equal shares, but they may have gotten their shares from somewhere else. So just because you've left some money in a special needs trust for one child doesn't preclude you from leaving for other children. And again, as Fiona was talking about, and Stephen, the other children could possibly, depending on how you draft it, be what we call remainder beneficiaries, get money that's left over.
Okay.
I know a common challenge is parents want to be equal with children. Well, first off, children are not equal, disabled or not. That's just not how it works, right? Here. So I think one consideration you have to really look at, and these are tough things to deal with, is trying to treat children equal. The situation is for most folks with disabilities, especially that need public benefits, once again, they have less options than the typical child. My prejudice is to, really consider funding the special needs trust a little bit more. But once again, that's a personal decision. We have to deal with what we want. The thing about it, and once again, since we have a fiduciary in the room here, part of it is we need to give the fiduciary enough resources to carry out what it is you ask them to do. I often see parents, well-meaning parents, put a lot of requests on what they want this trust to do, but they don't give the fiduciary the resources to do it. Well, that's really unfair. And I don't know. I mean, Fiona, what do you think?
Do you mean putting enough money in the trust?
Putting enough money in the trust or that kind of thing.
Yeah, I mean, I think that's something you have to consider just in general. What is the amount of money that is going to be in the trust and what can be achieved with that? You've just got to kind of create realistic, feasible parameters with what's there. I have some very small SNTs. I have some large SNTs. It just, it's, you just have to know what you can do with the money that's there.
Thank you. So moving on to another question here. Do SNTs lay out rules for the cadence of distribution over the beneficiary's life? Anyone want to tackle that one?
I'll jump on it. Part of this, oftentimes in the drafting of the trust, you are setting out rules, right? I mean, let's go back to this. What you're really doing with all trusts are contracts here, and everything has to do with what was the grantor's intent. What did the grantor want? If you draft a trust that says keep my kid on public benefits, we haven't told Fiona a darn thing. We haven't given her any guidance. So part of it is setting out what are the expectations, and then sometimes setting out rules, So for instance, I have trusts that are set up that really are meant to encourage folks to keep up with their vocational work and that kind of thing, and are set up to reward the beneficiary here and be more liberal when they're actually engaged in work and that sort of thing. And what they want to do is they want I was trained as a behavioralist here, so it's to reward good behavior and do your best to ignore bad behavior, a premise of behavioral care and that kind of thing. So you can set out the rules within it. And I think in sometimes it makes it a lot easier because, in the end, Fiona or I, when I'm the trustee of the Golden State Pool Trust, my job oftentimes is to say no, In fact, that doesn't always make me the most popular guy in the world. But, I look at the trust document, it says, this is what we're supposed to do, and this is how we're supposed to do it here. And those are the rules, and go, hey, it's not my rules. Mom and dad made this. I'm more than happy to blame mom and dad about this. But, once again, you need some guidance.
Okay.
We don't, keeping in mind that all persons with disabilities are individuals. A lot of the behavioral health cases that we have, oftentimes we have situations where folks are pushing the envelope and that kind of thing. And our job is to keep them on track to try to live the best life possible. So, you can put rules, you can put guidance here, both in the trust itself, and then you can also do it through this thing called a letter of intent.
Thank you, Stephen. So we have time for maybe a couple more questions. And I'll read this one outright. If you name charities in the event the Special Needs Trust trustee passes, parentheses, remainder beneficiary, do you have to notify them throughout the duration that the SNT is activated in annual reporting?
So I think they're talking about you name charitable remainder beneficiaries as the charities as beneficiary, not successor trustee. That's the trustee is a job. So I think there's but remainder beneficiaries generally are required to be able to access reasonable information during the administration of the trust. The law wants someone to hold the trustee accountable, and the best people to make sure the trustee is doing the right job are the beneficiaries, both the current beneficiary and the remainder beneficiaries. Fiona alluded to the fact that there is this reporting requirement so that they can know what's going on. This accounting requirement. You cannot, I believe, draft a trust that says, trustee, you do not have to talk to the remainder beneficiaries. The law requires there be some checks and balances. You may be able to limit how much information they get in the accounting unless they show that you're doing something wrong. But your charities have to be made aware that they're remainder beneficiaries and they have a right to ask for reasonable information.
Although you can draft a trust that says the remainder beneficiary is a secondary interest, because part of what you want to do is we have a lot of families where the remainder beneficiary is not their primary concern. And so, for instance, I am the author of the Wealth Council Trust, and it has language in there that basically you would still have the duty to account here, but that the trustee can basically spend it right all the way down to zero and not have to consider the remainder beneficiary.
The other thing you can do is you can give the beneficiary or maybe even someone else what we call a power of appointment to change the charitable beneficiaries. So if they start to make a lot of trouble and they're kind of getting nosy, you just bop them on the head and you just remove them as beneficiaries. That usually keeps them in line pretty much. But again, you know, they want somebody to hold the trustee accountable. So you've got that tension there.
Okay, maybe two more questions. And again, we won't get to all of them. Thank you everyone who participated in the Q&A section and wrote their questions out. Let's see here. Can one beneficiary have two S&Ts, parentheses, set up by different family members? Or is it better that there is a pooled trust setup?
So I'll take a stab at that. And I have, unfortunately, you know, like parents got divorced and they both want to set up special needs trusts for their disabled child, but they have different remainder beneficiaries. So one of the things I try to do is make sure that we coordinate between the two of them as to, you know, the trustees then talk to each other or can coordinate what comes out, which trust may be spent first. Is it done proportionally to the extent there's assets it's equal? So yes, the answer is yes, they can, but you really want to try to have a coordination between them so that you don't have the beneficiary asking for money over here and then it's the same money for the other trustee and they never talk and they get twice as much or they're getting their off benefits. Of course, it's wonderful if they can combine their two trusts, but a lot of times they maybe have very different beneficiaries and they really don't want to do that. But I have done one where they've combined it and we've then done a proportional distribution on the end based upon contribution. So if mom dies and 100,000 went in and dad died and 500,000 went in, when beneficiaries died, dad's beneficiaries get 5/6 and mom's beneficiaries get 1/6.
Okay.
I have one trust, although I get all the strange ones. I have a family with a beneficiary that has 6 special needs trusts. Try coordinating that here. You know, one thing that comes up, which is common with people with disabilities, is that the incidence of divorce is relatively high here. So we'll get a lot of situations where if the family is working together, and I'd say that happens about half the time, I prefer a single trust. And the two issues you're normally dealing with is who's going to be the trustee. My preference is to name a professional trustee. And the other part of that is where does the remainder go? And so you can actually draft something very similar to what Yvonne was doing in a single document here that basically has language that based on the proportional amount of contribution for each family member, it would do exactly what Yvonne was talking about. It would parse it out to the remainder beneficiaries according to that. And each of the family members would have their individual power of appointment which means where the money goes upon death. When it works, it's a wonderful thing. The other half of the time, that's just not going to work. And then you're going to be in a situation with 2 or more trusts. When they all work together, like apparently Yvonne in that case was able to tame the trustees and get them to work for her here. I have not been fortunate in every single case. I have had situations with the battling trustees where, you know, I have one where one trustee, and there's nothing that says you're going to do that, intends not to spend a cent until all the money's gone. By the way, you'll never guess who the remainder beneficiary is of that trust. It's the trustee.
Thank you. Thank you. Okay. Last question before we segue into the next portion here of the webinar. How do you ensure a trustee doesn't take advantage of their role?
Well, that's you know a great question, and from a you know it's difficult in from a practical point of view. But again, that's why beneficiaries, both current and remainder, have certain rights to receive information so they can keep track of what the trustee is doing. When the trustee is also a beneficiary, a little more difficult. And then that's another reason why sometimes we look at trust protectors, having that third party be able to access information. and you have that problem, whether you have an individual, a professional, or even a corporate trustee, when anytime you have someone as an individual, there's a potential for abuse.
This is where a trust protector or an advisory committee, and by the way, when they work, they're a marvelous thing. When they don't work, oftentimes it's pretty spectacular here. But there's a couple of things to look at. Beneficiaries are always required to have accountings available. But if your beneficiary has a cognitive disability, how effective are they going to be going through an accounting and that kind of thing? This is another reason why accounting to like a family member through a trust protector or something like that might be good. The other thing is that most trust protectors have the ability to hire and fire. And when we get down to succession, in many cases, my experience has been with most trustees that if for some reason the family is unhappy with the trustee, the fiduciary, I've had very few situations where the fiduciary wants to fight to keep the job. It's mostly like, show me the door, if there's a success, or we'll do the final accounting and move out. The relationship between the fiduciary and the beneficiary is it's a very personal relationship here. And once again, under the best of situation, they're going to work as a team. If you have a situation where it's just constant friction, it's no fun for the beneficiary, and it's definitely no fun for the fiduciary. Yeah, and then, but I think the point of the whole thing is, did I mention that disability and simple are two words that don't go together? Part of this is too many people look at this as buying a document. And I think part of what you've seen here is that what you really are looking for is somebody that has experience in doing these things and have, seen mistakes that have been made and can kind of counsel you on these kind of things. The other thing with the fiduciary is that, the licensed private professional fiduciary is a godsend here. And it's something that, you really need to learn about. They provide a really essential service. And the other part of this is, for folks that have a passion about caring about persons with disabilities and that kind of thing, you might want to consider becoming a private professional fiduciary, somebody that understands the challenges of people with behavioral health. You're going to have an insight that just, quite frankly, can't be taught, and that makes you a very valuable person. Anyway, thank you for having me.
Thank you. Thank you so much. Now, thank you all again for the panelists and those who participated in the Q&A segment. Now I'd like to play a 3-minute video of a longtime supporter and board member of Interim, Carl Miller, detailing his personal experience with special needs trusts. We might be having some technical difficulties here. One moment. Okay. Thank you. Here we go. There we go. Thank you.
Why do you need a special needs trust? Well, one of the main reasons why people tell you is it allows your family member, if they're getting resources like SSI, like our son is, and Medi-Cal, that they can continue to receive that and then have access to any wealth that you've accumulated, as long as it's used for special things. And this is a real specialty in the law, that you really need somebody to look out for that. So the main reason I see for a second needs trust is to keep that support network intact. And how it should be, it really should be seamless. When the last of the parents pass away, There should be everything in place to take over and keep things in continuum. One of the biggest things that you need to concern yourself with is who's going to administer this. And this is and who's going to write this special needs trust for you. You're taking an important first step by looking at this video, because obviously you realize that you need something in place. Interview the lawyers, see what their expertise is. One question you're going to have is who administers this this trust. You need somebody to look after to make sure the wealth you accumulated will last and serve them. One thing that we're going to do is try to find an administrator to pick up when my wife and I are no longer there to help. And this is very complicated because the wealth you do have, you want to be invested, and that takes a certain skill level. You need somebody who stays abreast of the law, keeps the trust out of trouble. How does it help the beneficiary? Well, again, it just has that support network in place to pick up when the parents are no longer there. Just taking the time to interview lawyers, to interview administrators is the one piece of advice that I would recommend. What advice would you give to a family member who is planning the needs of a beneficiary? Well, like I said, do your homework, talk to groups like Interim. You're taking the first step by looking at this video, but it's only the beginning. This is a specialty part of the law, and it does take a certain amount of expertise. You probably have a lot of questions. However, Interim can be of assistance. I encourage you to reach out to us. Good luck with your family member. I hope that things work out, of course, but I hope you're able to put something in place that will take care of them and be there for them.
Thank you so much, Carl. So in closing, I want to thank our speakers again for this informative discussion and all of you for attending, asking insightful and engaging questions, and most of all, for thoughtfully considering how best to care for your loved ones. As you've seen over the last hour and a half, there's a lot of moving parts and different options available to you, so timely planning and consultation with professionals are essential. While the content of this webinar is relevant to loved ones of persons with disabilities, we're here for you at Interim if you have any questions or concerns about any of your loved ones living with mental illness. Special thanks again to our esteemed panelists and presenters, Yvonne Ascher, Stephen Dale, Fiona McDonough, and Carl Miller, as well as those behind the scenes making this webinar possible. Thanks as well to Interim's Board of Directors who supported the effort to help bring this webinar to the community. And of course, a special appreciation to everyone who tuned in tonight. Thank you and be well.